intentionally commits murder as hereinbefore defined, and the person intentionally or knowingly causes the death of more than one person during the same criminal transaction. Mental state definitions. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to the result of his conduct when he is aware that his conduct is reasonably certain to cause the result. Term definitions. Deadly weapon means a firearm. Firearm means any device designed, made, or adapted to expel a projectile through a barrel by using the energy generated by an explosion or burning substance, or any device readily convertible to that use. Individual means a human being who is alive. Person means an individual. Criminal responsibility for conduct of another. A person is criminally responsible as a party to an offense if the offense is committed by his own conduct, by the conduct of another for which he is criminally responsible, or by both. Each party to an offense may be charged with commission of the offense. A person is criminally responsible for an offense committed by the conduct of another if acting with intent to promote or assist the commission of the offense, he solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. Mere presence alone does not make one a party to an offense. Application paragraph for capital murder. Now, bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about the 26th day of December 2021 in Dallas County, Texas, Abel Acosta intentionally or knowingly caused the death of Rafael Garcia, an individual, by shooting Rafael Garcia with a firearm, a deadly weapon, and during the same criminal transaction, Abel Acosta intentionally or knowingly caused the death of another individual, Ivan Loyola or Xavier Gonzalez, by shooting Ivan Loyola or Xavier Gonzalez with a firearm, a deadly weapon, and Richard Acosta Jr., the defendant, acting with intent to promote or assist the commission of the offense, did solicit, encourage, direct, aid, or attempt to aid Abel Acosta to murder more than one person during the same criminal transaction, then you will find the defendant guilty of capital murder as charged in the indictment. Unless you so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant and say by your verdict, not guilty. You are instructed that it is your duty to consider all relevant facts and circumstances surrounding the alleged killing and the previous relationship existing between the defendant and the deceased together, with all relevant facts and circumstances going to show the condition of the mind of the defendant's mind at the time of the alleged offense. Extraneous offenses. You are further instructed that if there is any evidence before you in this case regarding the defendant's committing an alleged offense or offenses other than the offense alleged against him in the indictment in this case, you cannot consider such evidence for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offense or offenses, if any, and even then you may only consider the same in determining the motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake, or accident of the defendant, if any, in connection with the offense, if any, alleged against him in the indictment and for no other purpose. Grand jury indictment. A grand jury indictment is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence of guilt, nor can it be considered by you in passing upon the question of guilt of the defendant. The fact that he has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. Burden of proof and presumption of innocence. The burden of proof in all criminal cases rests upon the state throughout the trial and never shifts to the defendant. All persons are presumed innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of the evidence. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charge beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt, but it is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit him and say by your verdict, not guilty. Concluding instructions. Neither the statements made by the attorneys nor questions asked by the attorneys are evidence. Nothing the court has said or done is evidence, and you will not consider the remarks, rulings, or actions of the court during this trial as any indication of the court's opinion as to the existence or non-existence of any fact, or as an indication of the court's opinion as to the guilt or innocence of the defendant. You are the exclusive judges of the facts facts proved, of the credibility of the witnesses, and the weight to be given their testimony. But the law you shall receive in these written instructions, and you must be governed thereby. After you retire to the jury room, you should select one of your members as your foreman. It is his or her duty to preside at your deliberations, vote with you, and where you have unanimously agreed upon a verdict, to certify your verdict by using the appropriate form attached hereto and signing the same as foreman. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case which is not shown by the evidence. No one has any authority to communicate with you except the officer who has you in charge. After you have retired, you may communicate with this court in writing through the officer. Any communication relative to the cause must be written, prepared, and signed by the foreman, and shall be submitted to the court through this officer. Do not attempt to talk to the officer who has you in charge, or the attorney, or the court, or anyone else concerning any questions you may have. Your sole duty at this time is to determine the guilt or innocence of the defendant under the indictment in this cause, and restrict your deliberation solely to the issue of guilt or innocence of the defendant. Following the arguments of counsel, you will retire to consider your verdict. I sign this, stepping up, the presiding judge of the 291st Judicial District Court. The last page of the charge contains the verdict forms. The verdict forms read, we, the jury, unanimously find the defendant, Richard Acosta Jr., guilty of the offense of capital murder as charged in the indictment. And there is a line for the presiding juror to sign and print their name. There is also, we, the jury, unanimously find the defendant, Richard Acosta Jr., not guilty. And again, there's a line for that presiding juror to sign and print their name. We're now going to have closing arguments. Because the state has the burden of proof, they get to open and close closing remarks. State, do you wish to make opening remarks at this time?
Yes, Your Honor.
You can proceed when you're ready.
Thank you. May it please the court.
Nay.
Thank you, Judge. Well, good morning. On behalf of the District Attorney's Office, my staff, the citizens, I appreciate, number one, that you responded to that summons, okay? If you hadn't, you wouldn't be sitting here today. But that summons, and I want to remind you some of the things we talked about earlier this week, just Monday. It's been a short week in a sense, because from Monday to Friday, we're going to conclude this case. And we talked about why we're here and how special we are, how special you are to us, because we live in the United States of America. We live in a country where people fight to be like us, or even just a little bit like us. But we're governed by our Constitution, we're governed by a state constitution, we're governed by laws, a penal code, we talked about that, the elements of the offense, we talked about procedure from a code of criminal procedure, and we talked about the very special nature of coming down for jury duty, and how we continue that special thing we have called America when you show up. And I kind of gave you a preview of how this case was going to go. I told you that you were lucky to be where you were on Monday. I told you we had a great judge. You've seen that. I told you that we all know each other. We all collaborate, we cooperate, we share. You've seen that. I told you don't expect to see any TV drama and all that nonsense that goes on. That's not how this case is going to go. What you've seen and heard is that everything we have, they have. Is it a little confusing sometimes for both sides because of the volume of it? Yes, and we'll both ask you to forgive us for that if we've made any mistakes or missed a little something. That's okay, but we got it right. Okay? And then we talked about the law. And we talked about the law surrounding murder and capital murder, and we were very honest with you about this case. We told you that there would be no dispute as to whether or not 3 young men, 3 boys, teenagers were dead. And we told you there wasn't going to be any dispute as to whether or not a certain person caused their death. We told you this was about the law of parties, and we went through and explained that. And the judge has given that to you in the instructions. And if you give me a moment, I'll go over that. We talked about the fact that a person, and we used kind of an example, and I'm not going to go into the details because it's unnecessary, okay? But we talked about the Oklahoma City bombing. Some of you remembered it, some of you didn't. And we talked about in that case that Timothy McVeigh and Terry Nichols were held criminally responsible. Okay? When? What? No physical evidence. We have fingerprints here. We have photographs. The truck was blown up. No DNA. Don't have that here. We got security cameras. And we told you that Timothy McVeigh was held criminally responsible. But also the example of Terry Nichols, who wasn't even there, was held criminally responsible. And you can see that in this case, we certainly have much, much more evidence in that. Because we have video. And we know who was there. And we know from the testimony who was there. Okay? So let's talk about where we were. First of all, there's no question that this was a horrible, terrible, senseless crime. But we don't know why. And we asked you on Monday, if we didn't know a motive, if we didn't have a motive, if we didn't present a motive, could you still return a verdict of guilty if we followed the law and proved the elements of the offense charged? And you said yes, and that's why each of you is sitting here today, because you said you would follow that law. But preceding that, the judge gave you an oath that said you will true answers to all questions propounded to you by the court or under its direction. And that's under this framework we asked that. We counted on you Monday, and we're counting on you today to follow that oath. And then we told you another thing. You're going to get another oath when you come in here, that you will true verdict render according to the law and the evidence of help you God. You said that you would. And we counted on you Monday or Tuesday. And we're still counting on you today. And we also told you, and the judge has now again told you, in her instructions, that you're the exclusive judges of the facts of the case, the credibility of the witnesses, and the weight to be given the testimony. And that is true, and you said you'd follow that, and we're expecting you to do it naturally. Okay? So what did we bring? I'm not going to drag these pictures out. There's been enough pain and trauma in this courtroom about what happened at that Texaco taco shop, game shop, smoke shop, or whatever. But I will go over it a little bit. Okay? So what do we know? Well, I think it's true. I think it's reasonable that somebody in this courtroom got a text to get some Tylenol. Let's talk about that. What we know is, just a few weeks before that, the love of his life was pregnant with twins. I know some of us have children. Some of us have experienced birth, and some of us have experienced tragedy because of that. And this was a story of tragedy because one of the twins didn't make it. Can you imagine as a parent the anticipation you have when you go through a sonogram, etc., you learn you're having twins, and the joy and all the things that you anticipate and dream about your children and twins and what they're going to be like and how they're going to be, and then to suffer from the knowledge that you have lost one of them, especially for the mother. It has to be devastating to her, and maybe is equally devastating to the father. But this whole story starts with, I need some Tylenol. Because what? This miscarriage had happened just a few days, a few weeks before. And so, with all this loving concern that one ought to have about the health and the safety of the mother who just had a miscarriage, goes into that place to buy what? Some Tylenol. Well, something else starts happening. What do we see? Security camera out there starts showing what's going on in the car to the extent that we can see it. What else do we see? All that big black mark down the side of that car. Okay? And we see Abel doing what? Up, down, window up, down, moving around. We see a cap. Okay, we see all that. We see him go inside, get the Tylenol. We see those other boys walking around in there. He his own admission sees them walking. Okay? What happens? He goes out, they get in the car, he's pointing. Who happens to be standing right where they're pointing? Those boys. And poor Xavier, he's just sitting there waiting on his tacos. And you know, sometimes you come down here, you realize how fragile life is. Xavier would have been there anyway. Those other two, the reason they lost their lives is they made a simple request. Yes, we want pizza, but we also would like some tacos. And if they had just been satisfied with pizza, you might not be sitting here today. That's how slippery life is in Dallas County. And so what else happens? We get the Tylenol. And we need to take it home to our loving wife who just had a miscarriage. And we put that car in reverse. You saw the lights, and we slip out. And with all those exits on that corner, we ain't going home. We've been pointing in the car. Okay? We've been pointing. What do? Bump the mirror. So what? That little bump was so inconsequential. Do you realize the police didn't even take a picture of it? Nobody cared. But all of a sudden, we're worried about this, and who's might call the police, who might get out the car. What's a reasonable thing to do? Get out the car yourself. If you're so concerned about it, call 911. They probably ain't coming up with that, but so what? Call them. Okay? Well, what's also going on? It's equal to the smoke shop. Okay? And don't forget, our loving wife who just had a miscarriage is at home waiting on that Tylenol. And what do? Slowly drive around, very slowly. And we don't park in a parking spot. We pull up parallel. What's the significance of that? A quick, easy, get in, get away. And we never put the car in park. We'll keep the foot on the brake. And the person who's sitting in the car with us now has that cap that was on the dash, now has a mask, no shirt on, slips around the back, and you can see the angle of the car to the building. It slips under where it couldn't be seen, even though you could see from the inside the cap. Opens the door and starts firing with a 40-millimeter gun with a large capacity magazine in it, probably 20 or so shots. Okay? What do you see? You see that gun going off, and you see the smoke coming off of it. You see him back out and go in. You see him go all the way in. And that smoke is important, because Armando told you when he went in to check on Paco, his nephew, what did he smell? Gun smoke. What did you see coming off the gun? Gun smoke. And what does he do? He goes into the store, and if he hadn't done enough damage as it was, puts the gun right up to Xavier and pumps some more in him. And what's the gun doing? Firing and smoking. You can see it. And what does that tell you? Who's got gun smoke on? Standing in it, firing it. Who's got a hot gun in their hand? His son. Who does what? Runs out, jumps in the car, and guess who's clueless? If you want to believe it. You saw the gun smoke. You saw him go run right into it, run right out of it, and go get in that car. And before he closed that door, the pedal was to the metal. And the sad thing about it, I don't know if you've thought about it, I want you to think about this. Okay? When we talk about criminal responsibility, when we talk about proving somebody is guilty as a party to an offense, first of all, we told you that we didn't have to prove, that this happened, that this was a plot and a plan that happened way before, that intentional and knowing acting can happen at the time. And certainly you see that. Okay? But what else is so damning in this case? While those boys were on that floor, that any member of the public has been stepping across for who knows how long, with dirty feet and shoes and whatever else, as they lay there, they told you they laid one or pulled one over. Of course, you saw Xavier, how he was writhing in pain. Of course, 8 of those bullets went into his bones and his flesh, and 2 killed him. No question about that. And the other 2 had fatal wounds. As those boys' lives were slipping away, slipping away. And his son, with a hot gun in his hand, and had created all that smoke, had stepped in and out of it and got in the back of that car. A reasonable person would have called 911. What does he do? Pedal to the pedal and get out of there. You don't see him stopping for any cars. You don't see him checking left and right. It's out. Then we go through the series of tracking the guns. I'm not going to go through all of that. Okay, you heard it. You saw it. You saw what the truth is. Okay, those guns go all, phones, I'm sorry. They go all over the place. Of course, we had all these questions about, well, just because it's a phone doesn't mean it's a person. Okay. We got rid of all of that. He took the stand. It's his phone, and it's with him. Okay? What else do we know? Well, we know that that car has a black stripe down the side from a previous incident with some other object, car, whatever. Doesn't make any difference. It's there. It's very recognizable. And somehow, from dark to dark, with no daylight in between all of this, this shows up because he's a guy who does what? Washes his cars in the middle of the night to go clean up something that's been there for several weeks. What else do we know? Okay. We got some things missing. We have a phone that winds up in Rockwall. Remember we said we could prove that somebody's a party to an offense by what they do before, during, and after? Okay. In the lake, most likely. Okay. What else? We have a missing phone. We have a missing gun. And we have a missing, most importantly, son. Never to be seen since that day. Phone goes off, poof, disappears, not sure why, want him back, all of that, the story. Okay? So, where does this leave us? We told you, we asked you, if we proved his actions as a party circumstantially, and we proved it beyond a reasonable doubt, could you return a verdict of guilty? We put that up. We asked you 2 different ways, and you said yes, you could. And we have painstakingly taken every bit of that video from every angle and put it together and showed you that when Abel jumped out of that car is when those 3 kids lined up right there at the front. We showed you painstakingly where the pointing was going on and who was where and who was in the store, where they had come from. This is a taco run for 3 kids that ends in their tragic death. But then you also learned something in the courtroom, that everything we have, they have. When we get it, they get it. And you also learned that everything we have, we give to him, and it's given to the defendant. And so we get this story. And one of the things we're allowed to do in closing argument is to use analogy. Okay? So the big story here is you have plotting right at the moment, you have planning at the moment, pulling out, going around, stopping, coming back, getting at an angle where Abel can get back in the car and go. And you have execution of that plot and that plan. And the person, as the law defines a party, acting with intent to promote or assist the commission of the offense, encourage, aids, attempts to aid, etc., etc. The offense is sitting right there. But he's had a while to think about it. And I want to use an analogy, if you'll allow me to, which we can in closing argument. You know, we all know each other around here. I want to give you an analogy. You know, some of you have children. I don't know how old they are, but they all go through age. You know, some of them go through the terrible twos, and it's like, what am I gonna do with this kid, right? Some of them don't. Some of them join up their mouths and their brains at the same time. In this case, and what you've heard from the witness stand, reminds me of a little boy who one day says to his dad, he said, "Dad, what does the word maneuver mean?" Think about that, son. He says, avoid, evade, get around. He says, like talking or doing? He says, well, maybe both. You could talk your way around something, talk your way out of something. You could physically do something. Put your phone in the leg. Lose the gun, lose your son. The boy says, okay. He comes back a few minutes later, he says, Dad, I got another question. I said, what's that, son? He says, I'd like to know if you can tell me, Dad, the difference between a maneuver and manure. And Dad says, you know, you got a point there. There might not be much of a difference. When you deliberate in this case, I'm going to ask you to be careful about the manure. I'm going to ask you not to step in it. If you do, don't slip in it. Because if you do, you get it all over you.
You can use 20 minutes.
Thank you, Judge. Because in this case, there's been a lot of manure coming up there from off that witness stand. And I want to juxtapose something. I want to juxtapose the seriousness with which you took your oath. And I expect all of you meant those oaths that you took that make us very special. But not everybody who walks into a courtroom here or anywhere else when they take the oath intends to tell the truth. And the story doesn't make sense, and it all falls apart, and it's nothing but a bunch of manure. And I'm asking you, based on the credible evidence in this case, okay, to find Richard Acosta guilty of the offense of capital murder, because we proved it beyond a reasonable doubt. He knows it. All of his actions that day and everything he's done since then leaves nothing but one conclusion, and that is he's guilty as charged. Thank you.
Thank you, Mr. Crusoe. Mr. Harrison Shackelford,
Yes, Your Honor. Thank you.
would you like a 15-minute warning?
2-minute warning. Thank you. Ladies and gentlemen, I first just want to thank you again for your time and your attention to this case. I know that it's been a long week for you guys. I was watching you throughout the course of the trial, and I could tell that you always seem pretty engaged. And believe it or not, that's not always the case. So I want to thank you for that. And I know that Richard appreciates that as well. But I'm just going to be honest with you. Some of the things that we saw this week, some of those photos, you know, the video of that shooting, it's hard to watch. You know, particularly as a new mother myself, it was hard to watch. It's just a terrible, terrible, terrible thing that happened that day. You know, these were young men that we're talking about, all of them. I want you guys to know that that fact is not lost on us. It's not lost on us at all. But I don't want it to be lost upon you how terrible this has been for Richard. Because above all else, Richard is a father too. And not just to Abel, but to little Marcus and Richard III, and who you don't see in that picture because his wife was pregnant at the time, Eliana. Richard is a parent, And December 26, 2021 was every parent's worst nightmare. Imagine what that must feel like. To find out, you know, okay, they were having some problems with Abel, but you heard Richard tell you, we thought that he was turning a corner. We thought things were getting better, you know? So then to realize that your son is involved in this terrible crime, has committed this terrible offense, and then he disappears, now you don't know where he is, still don't know where he is, don't know whether he's alive or dead. His face is all over the news, all over the social media, feels like everyone is looking for him for the worst possible reason ever. No parent wants that to be the case for their child. So all of that in and of itself is a lot to process. But then, to compound that, then you realize that the state wants to hold you criminally responsible for the actions of your son. Again, every parent's worst nightmare. Think about that. Because his life is literally in your hands today. I want you to keep that in mind when you're deliberating. Okay? I'm not going to go through all the details because Mr. Harris is going to come behind me. He's going to summarize everything for you guys. And like I just said, I know you were engaged the whole time, so I know you get it. For my purposes, I just want to make sure that you understand what we mean when we say reasonable doubt, because that is absolutely crucial in this case. Okay? It's one of those phrases that we hear all the time, but you'd be hard pressed to find someone that can actually define it for you. Probably why the legislature didn't do it either. Okay? We told you in board ire, it's something that's kind of left up to you to decide for yourself what that means. So let me explain it to you this way. Okay? I want you to replace the word doubt with question. If at the conclusion of the evidence, which is where we are now, you've heard and seen everything the state has to bring you, and that's their obligation. They're the ones that have to bring the evidence to prove Richard knew, not to assume that he knew based on the video, to prove to you that he knew. And you've seen everything that they have for you to do that. At the conclusion of all that, if there still exists in your mind a reasonable question as to whether or not he knew what his son was going to do, as to whether or not he did anything to aid, promote, assist, encourage that. If there's a single reasonable question in your mind about that, your verdict is not guilty under the law. Okay? All it takes is one. You can have multiple questions, but if you have one and the state hasn't resolved it because that's their job, and when Mr. Harris was telling you in more dire that you have to hold the state to their burden, that's what he meant. Any of those questions that are lingering in your head, it's their job to resolve those for you. If they can't do it, if they haven't done it, your verdict is not guilty. So what would a reasonable question be in this case? I think there's a few of them. First and foremost, is it reasonable to question whether or not Richard knew what his son was going to do when the state hasn't presented you a shred of corroborating evidence of that? All they presented you was a video. Oh, he's driving slow. It must be because they're casing the place. Oh, they're having a conversation in the car, so it must be because they're talking about what's about to happen. They're pointing, so it must be because they're talking about what's about to happen. They don't know that, and you heard the detective admit that on the stand. It's speculation. So it's one thing to speculate and assume, but what have they brought you to prove that that's what he knew? You heard the detectives tell you about all the searching they did, all the investigation they did. They executed search warrants at his house, at his wife's house. They searched his truck, they searched his wife's car. They dumped her phone, they went through messages, they went through social media, they went through trash. They did fingerprints, they did DNA, they did all of that stuff. And through all of that investigation, what did they produce that corroborated what they think he knew? Nothing, because it doesn't exist. So is it reasonable for you to be sitting there questioning that? Absolutely. Is it reasonable to question if you were going to be involved in a triple homicide, why you would first go in the store with no mask so everyone can see your face on the cameras, use a debit card with your name on it, and purchase Tylenol, and then go back in the truck that's registered to you? Does that make sense? reasonable to question why you would do that if you knew what was about to happen? Absolutely. If they can't resolve that question, then your verdict is not guilty. And most importantly, is it reasonable to question whether or not their version of events is true when Richard told you what happened? He explained all those things to you. No, I wasn't driving slow as we were casing the place. It's because I just had a collision with Armando. And guess what? There's actual evidence to show that. Armando got up there and testified and told you they had a collision. Armando told you that his mom was wondering, hey, should we go talk to the guy? Armando and Richard are sitting there thinking the same thing. You heard that for yourself. He told you he was getting Tylenol for his wife. There's a receipt to show that. You saw him doing that on the video. Where's the evidence to back up what the state is saying? There is none. So is it reasonable for you to question all of that? Absolutely. So if you have any unresolved questions, your verdict is not guilty. If you're sitting there thinking, I believe what Richard told me, as you should because that's the truth, your verdict is not guilty. However, if you're sitting there thinking, I don't know what to believe, maybe the state is right, guess what? That's a not guilty. Maybe he knew, possibly he knew, probably could, he knew. All of that, not guilty. None of those words are good enough to send a man to prison for the rest of his life. Okay? I just want to make sure that you guys are clear on that. As I said, that day was a terrible tragedy. I think everyone in this courtroom already understands that. We know that. We essentially lost 4 lives that day because you heard Richard tell you that he feels like he lost his son too that day. So that's 4 lives. Do not add a 5th life to it unless you were absolutely sure. And I would submit to you that with the evidence that the state presented to you this week, assumptions based on speculation, with nothing to back it up, there's no way you could be sure. That is why we're asking you to return a verdict of not guilty. Mr. Harris is going to come talk to you. Thank you, guys.
Judge, can I have a second?
You may.
Oh, they're up there. Underneath that second set.
You have 34 minutes left.
Oh, at the bottom? At the bottom? Oh, okay. Still a no. Okay. May it please the court?
You may, you have 34 minutes left.
Thank you, Your Honor. Ladies and gentlemen, again, I want to thank you for taking time out of your busy schedules to serve on jurors. Like I told you earlier, I know there are a million reasons y'all could have given us to allow us to strike you. Again, given the facts of this case and what we tried to let you know was going to be gruesome. But y'all didn't do that. You accepted responsibility to serve as jurors, and for that, I thank you. The Acosta family thanks you. But now, more importantly, it's time for the state to accept responsibility for the evidence that they presented to try to prove this case beyond reasonable doubt. And I submit to you, they haven't proved the case beyond reasonable doubt, not just because you can't speculate, and with all the editing, all the work, the hard work, all the, stuff that the Guardian Police Department did, arresting people, harassing the Acostas, trying to force them to cooperate. And he's right, this is the United States. They didn't have to cooperate. And if they want to charge the Acostas with tampering with evidence or hindering apprehension, do it. We'll be right back here. It'll be the same result, not guilty. But they charged Richard Acosta with capital murder. And because they charge him with capital murder, they have to prove beyond all reasonable doubt that he's a party to the offense. We know he's not the shooter. You see that on the video. But the problem is, again, when a jury, we talked about reasonable inferences. But the bottom line is, you're not permitted, you can draw reasonable inferences from the evidence, but what you can't do is make legal conclusions from speculation. From speculation. You can't make legal conclusions from speculation. There has to be evidence to support that speculation. So even all the pointing, it's speculation. You know, he's on the break. There are a million reasons why he could have been on the break. He told you why he was on the break. He never turns the car off. He's in a rush. He's trying to go home. They have to prove that they haven't done that. Not just that he was merely present at the time of the offense, but that he knew that offense had occurred. Not that he heard the shots, saw his son, or heard his son open the door after he ran back to the car. Hearing shots does not mean that he saw what happened. He told you he didn't see it. He was distracted. He was looking the other way. They haven't proven otherwise. That's just as likely. There are a million things he could have been doing in the car. Unfortunately for him, he wasn't watching that door. He told you why he was focused on this door. And they know that's reasonable. So that's why they start throwing stuff in. Well, that door's locked. Who? What witness? The detectives, we went to the location. The store owners, what witness came to you and told you that that smoke shop door was locked on that day? Not one. But again, they want you to speculate. Oh, that door was locked. What happened to you here from the witness stand? From the videos, all those officers that went out there. Talk about manure. Do you really believe if that door didn't open, they would have someone get on this witness stand and tell you that? He said he didn't know. And even if it was, he saw his son go toward the door. Manure? Yeah. That they wouldn't bring someone to tell you that? Ladies and gentlemen, again, they have to prove that as he's sitting in that car, as he's sitting in the car, when those shots go off, when Abel goes to that door, he's watching that door. They have not done that because it did not happen. He told you what he was doing. Again, I told you from the beginning, this was going to be emotional, you know, we're going to waterboard you with all this graphic facts. And it is graphic because it was a horrific murder. These murders were horrific. You know, but again, Officer Goodwin, those Garland Police Department, they bring you the evidence they want you to have. But y'all know exactly what's going on here. Y'all know exactly what's going on. Karma. That was about karma. I don't know why Abel was carrying a gun that day. I have no idea. We can speculate. Maybe it was for protection. Based on what you know. Maybe it was for protection. Maybe, had he driven off, we can speculate that had Richard Acosta driven off that day, based on what you know about what was going on with these kids, maybe he'd be sitting over here. And they'd be sitting over there. Because of everything that was going on. But that would be speculation, right? You know, he's just, Garcia, Raphael just happens to have that black bandana on his hand, you know. NSB, 5L, you know, was this, gang. Remember the three texts for Dia sent them? Why is she sending those texts? They're trying to figure out, why did this shooting happen? Why did they, because they don't believe that Raphael Garcia's involved in no actions like that. You know, he's a runaway, hanging around with Ivan and Isaac. They don't approve of that. Why? Why? His son hanging around or doing things that he doesn't approve of, he doesn't know about. He could easily be sitting over there. If you believe that this could have been about karma. Was Abel carrying the gun for protection? Come on, we don't know. It's all speculation. What we do know is that he told you when I picked my son up at the mall, I never saw him with a gun. When he exited the car, I never saw him with a gun. They haven't proven otherwise. They can talk about how big, it's impossible. It's not impossible. He didn't see him with a gun. And then they want to minimize the bump when he runs into Armando's car. Armando didn't minimize it. He told he thought the guy was drunk because when the dude stopped, he said, I thought he stopped because he hit my car. That's what he said. That's what he said. And that's real. That's what people do. And they're taking off the shirt. Oh, we just made that up. Doesn't that make sense? For those of you that got kids, arguing with these kids these days, what he told you about his relationship with his son at that time? He's trying to keep him in the car because he's ready to go. The son wants to go, according to him, address these boys. But you see on the video, and if you look closely, again, whenever they're pointing, and I submit to you, he's not pointing in the store. He's just saying, who? He's doing like this. Who? What? What? The dude with the mullet? What? What? He's not pointing in the store. They can't prove you beyond a reasonable doubt. That's speculation. They want you to make an inference that they're looking at them. They haven't proven that. He told you that's not what happened. He told you that. That's all speculation. The lead detective had to prove it's all speculation. But what I want you to look at is when they back up, he's laughing. So again, he's jovial, talking about the boys. I know they know who has my necklace. Abel is not mad, according to him, at the boys. He's mad at him. They're arguing in the car. That's how the shirt comes off. The fact that he puts on the cap, again, that's not his focus at the time. He told you that. The fact that he puts on a surgical mask, the mask, like a million other people were doing at that time period, it's not important to him. He doesn't remember whether Abel had a mask on when they went to Kroger or not. Because it wasn't that big deal. Some people wear masks. Some of you got masks on. Some of you don't. It wasn't a big deal. He didn't think anything of it. Go in, talk to the guys, come back out. Why were you on your brakes up top? Yeah, because I was looking to see if the guy was going to get out. I was looking to see if he was going to get out. He never got out. He never gets out. He never gets out. He never gets out. Okay, I'll go. But when I go, I'm still arguing with this with my knucklehead son. You see what you made me do? Look, hey man, keep your hands off me. Yep. Well, you parents, y'all been there. It's hard parenting these days with all the information, all the things our children have to deal with, the social media, the bullying, the gangs, all the stuff that they have to deal with these days. It's hard keeping track of what your kids are doing. I asked him about the photos of Abel that they got off his Instagram account, Menace to Society. He doesn't know his son has an Instagram account, Menace to Society. He doesn't know that. When Abel got in trouble, this is the Abel he thinks he's dealing with. He knows nothing about this Abel. He knows nothing about that his son is putting gun photos on his Instagram account. He knows nothing about, that's not the son he knows about. That's not the Abel he knows about, that he's trying to encourage to play football, that he's going up to the school checking on, trying to make sure that he's doing what he's supposed to do. But he's not. He's not. He's even thinking about taking it to another area, so maybe that'll be a difference. This is who he was trying to mold. But unfortunately, just like Mr. Garcia, he's a runaway. When he gets mad, he runs away. He runs away, and that's what he did on this occasion. Did some stupid stuff, and then he ran away. He ran away. This case is about Abel Acosta. The horrific shooting that you saw is about Abel Acosta. I hope and pray that someday they catch Abel Acosta, so he can tell you the same thing that Richard Acosta told you. He did not know, number one, he was going to commit the crime, and he didn't see him do it. Oh, now they bring in, oh, he had to smell like gun smoke. There's no evidence of that. Absolutely no evidence of that. There's absolutely no, but again, they're desperate. They're desperate. That's why they bring in the tarot card dude. The information about that they know it's crap, manure. Because they need help. They need help because at the end of the day, remember I told you, we talked about Des Bryant, and Des Bryant will tell you today, I made that catch. I made that catch. Cowboy fans, Cowboy fanatics will tell you he made that catch. But when you apply the rules of the law, they wouldn't catch. It's the same thing here. They all believe Richard Acosta was a runner. He was a getaway driver. He was a getaway driver. But in order for you to be the getaway driver, you have to know what offense you're driving away from. Mere presence or flight from an offense does not make you a party. It doesn't make you a party. Whether they like it or not, it doesn't make you a party. You have to know what the offense was. If he's fleeing from that location because his son comes to the car saying, get out, or they, hey, go, they're shooting, go. He does what any other reasonable father, what any other reasonable person would do. He gets off the brake and he goes. He gets out of there. The fact that he doesn't turn around and, son, do you have a gun on you? That's reasonable. He wouldn't be doing that. He'd be driving, trying to get home. Now the son is in the back seat, the same seat that they searched, he's in the back seat. He has no reason to look around at that time because he's trying to get out of there. Why? Because they're shooting. That's the information he had. Again, gets home, Abel never tells him that he's the one that did the shooting. He didn't see Abel with the firearm because Abel runs upstairs to his room. They can't disprove that because that's what happened. Again, getting back to the Cowboy game, again, I told you the reason the Cowboy game would be so important because this was Sunday night football. He was distracted because he's listening to the game. Hurry up, go do what you're gonna do. Hurry up, go ask him about your necklace. Don't be in there arguing, don't be in there fighting. Go find out who has the necklace and come on back. Find out who has the necklace, son. Find out who has the necklace and come on back. Hurry up. Oh, now go. He goes. But he goes to the back. Again, that's undisputed. You see that. When he goes out of the car, he tells you what he's doing. He's already positioned like this. Yes, his foot's on the brake, but he's positioned like this because he's telling this boy, come on, man, hurry up. That's what he's telling them. And they can't disprove that. So yeah, he jumps out of the car here in a rush. But his attention is focused on turning up the radio. And oh, there's a Mundo. Is he gonna get out? Cowboy score! Is he gonna get out? By then, you hear the shots. He tells you he immediately goes down. The duration of the shots. And by the time he does look up, he looks back toward the smoke shop because that's the direction that his son went. That's what he told you. But by the time he looks back, his son is already at the car, opening the door, yelling. He gets off the brake and he goes. That's reasonable. He never looked toward the door because his attention was distracted elsewhere. That's what the credible evidence shows. Why? That's what he told you. That's what he told you. Now they'll say, molding, maneuvering the evidence, looking for the evidence. That's what they've been doing the whole time. Rather than looking for Abel Acosta, they're trying to find ways to convict Richard Acosta. That's what this is about. Again, him washing his car, Okay, charge him with tampering evidence regarding a shooting. But that still doesn't mean he knew that there was a murder that took place. He told you he heard the shots. So charge him with tampering evidence regarding a shooting. That's all it is. The brakes, again, he told you while he was on his brakes. Yes, he was ready to go. But he told you that his attention was not on the door, and they haven't proven otherwise. Not without just, them speculating. He had to be looking that way. When the shots go off, a reasonable person would have looked. Maybe. A million different reactions that a person would have in that moment. His reaction, unfortunately for him, was not looking at that door. His reaction was, he's here, he goes down. He goes down because shots are being fired. He hears them. That's what happened. They can't prove otherwise. Not beyond a reasonable doubt. Not beyond a reasonable doubt. They arrest Joshua, and he tells them, they're not just detaining him, they arrest him as a suspect. They're questioning him. They take his DNA, they take his fingerprints, they rule him out. Because they're under a lot of pressure, they need to find a suspect, and they need to find a suspect quick. He told you, they told him they had the shooter. He's thinking, oh, okay, well, that's what whoever Abel was talking about said was shooting. He didn't know at that time, is what he told you. He tells you, he goes over to Garland to talk to the people. No, I'm not going to cooperate I don't know what Abel knows, that's why I'm looking for him, because I want to know what happened in there, what happened. Why were all those shots? Why were you so scared? Why were you running? Why? He doesn't know. And they can't prove he did. But it would be reasonable that even if he thought they were looking for his son regarding what happened inside that store, the shots inside the store, that he's going to go and try to find out. And now they want to talk to him about, these shots. And he says, whoa, I want a lawyer. Oh, now he's Mr. Bad Guy. Oh, now, no. You don't cooperate? Well, in the United States of America, the laws that govern us, you have the absolute right to have counsel with you before you talk to authorities, law enforcement. And you better have it when you talk to Garland Police Department. And that's what he did. He exercised his right to have a lawyer before he cooperated, or before he told what he knew. And with his lawyer, he told y'all what he knew. And that was that a shooting took place, because he heard the shots, but he didn't know a murder happened. He didn't know a murder happened until he received, or he didn't know that they were even looking for him until he received the text from his friend, I think Keith Wright or whatever it is, when he sent him the photo of him. That's when he goes over there. And is he suspecting that Abel could be in some trouble? Absolutely he is. So again, ladies and gentlemen, all this stuff about these phones and all this, hindering apprehension of Abel Acosta, tampering with evidence, that would be the appropriate charges. Not capital murder, life without the possibility of parole, based on speculation, because that's what the lead detectives had to admit, that everything that they told you is speculation. And again, ladies and gentlemen, I submit to you that you can make reasonable inferences, but what you can't make is legal conclusions based on speculations. Now, there is a caveat to that. When you have credible circumstantial evidence, right? Credible circumstantial evidence or strong circumstantial evidence is your fingerprints, my home is burglarized, your fingerprints are in my home. I don't know you, I've never given you consent. Your prints are in my home, on my dresser, on my door. That's circumstantial evidence. That is scientific circumstantial evidence that a reasonable juror could infer. If I never gave this person consent, his fingerprints shouldn't be in my house. His print is by the door that was broken into. Yeah, you can make a reasonable inference and conclude that that is strong enough circumstantial evidence to convict somebody. If your male semen DNA is inside my body, a female or male, these days, whatever, and I haven't given you consent, that is circumstantial evidence that you can rely on. That's the level of circumstantial evidence that a juror would be allowed to draw a legal conclusion on. Not just speculation. Not speculation. You know, the fact that his break, there's a million reasons why he was on his break. He told you the logical reason why he was on his break. The fact that he watched the car, that doesn't mean he knew the offense. Doesn't mean that. There's a million reasons you watched this car. Well, it's been the beginning of the week. I've already got an accident. Now I want to watch the car and I want to, you know, go on with my day like I do every Monday morning. Get up in the morning and go to work. Ladies and gentlemen, again, I submit to you that there's more going on here. There's more going on here. And you should want to know. And because you should want to know what was really, you know, they say they don't have to prove motive. And they don't. But if they're going to charge a man with capital murder, and there is evidence out there that would go to the court. Don't you want to know? Don't you want to know? Why these boys? This was no contract killing. We know they didn't go to Texaco for the purpose of pulling this. What was it about these guys that caused Abel Acosta to shoot them and kill them in the manner that he did? What was going on between, you know, this group and Abel Acosta's group? What's going on? Why? And they don't have to prove it. They don't have to prove it. But it helps. It would help you understand why Abel Acosta would have been walking around with a gun. Why Abel Acosta would have hidden that gun from his parents, specifically from his father. It would help you understand why this horrific shooting happened. No, they don't have to do that. But it would help you get over your reasonable doubt. And because they haven't done that, because you don't know why this horrific thing happened, you know, if we knew why, maybe then you better understand why he didn't know, if we could get into it. Why he didn't know, you know? His son was carrying a pistol. He told you, I didn't know my son was involved in any activity like that. I didn't know. Other than the few problems that he was having in school, we'd go up there, we'd check. He'd run away. We went to the police to report him. We were trying to be good parents. We were trying to be good parents. A good parent would not allow their 14-year-old son to go in and commit an horrific crime like this. I mean, it makes no sense. If he knew, think about it, ladies and gentlemen. Think about it. If he thought that Abel was going to do something of this nature, wouldn't he went in with him? They said he had a gun, even though he tells you, I didn't have a gun that day. Wouldn't he have gone in with him? You don't know if these boys are armed or not. Why have you seen your baby in there? You wouldn't. You wouldn't. And he didn't. He didn't. He's distracted by the Cowboys game, sitting there not paying attention, distracted, not knowing what his child is doing. You know? And you know, unfortunately for some of the families in this case, you know, they didn't know what their children were involved in. They didn't know. Specifically, he didn't know. And, you know, the state talks about how they just chose to get pizza that day, rather than the tacos, you know, maybe this wouldn't happen. Ladies and gentlemen, this is way more about than pizza and tacos. You know that. You know that. You know that. They don't have to prove a motive, but for them to try to say that he knew that something like this was going to happen, you know, they haven't proven that. He told you exactly what happened, why he was distracted, why he never looked toward the door, why he didn't see Abel run to the car with a gun, why, you know, again, when Abel gets in the car, he's not looking back at his son. He is asking what happened, but I think his words were by the time he got, said something about he's like a caged animal or something, a panther or something, whatever he said. But he's hysterical, he's, you know, they're shooting, he's acting hysterical. He's like, just let me calm down, just let me calm down, just let me calm down. His problem is, again, because of his wife's condition, he doesn't want to excite her. So, okay, I'm gonna do some things that I wouldn't ordinarily do. I'm gonna deal with this knucklehead, and I'm gonna do some things that I wouldn't ordinarily do. I'm not gonna cause a fight with him at this gas station because he wants to go in and, you know, ask these boys about his name. I'm trying not to cause a fight, but here we go again. We're fighting again. Here we go again. This is gonna escalate over into the house. Then it's gonna upset my wife, and we're gonna possibly lose yet another child. That's reasonable. So you let him do something you wouldn't normally do. He should have left. He should have left. He knows that. He should have left. He knows that, but he didn't. He didn't. He sat there listening to the game, and the shots go off. He does. That's reasonable. That's what happened. Never sees him at the door shooting into the store, running in there shooting. He's ducked down because there are shots going off before he can even realize, oh, my son is in the store. Oh, manure. Oh, my son is in there. So he looks to where his son was, and that's this way, because that's where he saw his son going.
You got 3 minutes left.
Thank you, Judge. That's where he saw his son going. They can't disprove that because that's what happened. They need to disprove that. They need to speculate. They need to give you conjecture. They need to find some way, something in all this evidence, all this editing, all the phones were here. Maybe he had died. They need to find something to prove that he knew this offense happened. Not just a shooting, but that the offense happened, that he was looking at Abel. They haven't done that because that's not what happened. Not beyond a reasonable doubt. Oh, all this stuff about Terry McVeigh and Nichols. This ain't Terry McVeigh, this ain't Nichols. And this ain't Oklahoma. This ain't the federal government. This is the 291st Judicial District Court in Dallas County. And they had every opportunity to present whatever whatever evidence they wanted in this case. And they can say, oh, well, they got all the evidence too. We don't have no burden to prove to you. They have to prove. And they haven't done that. They haven't done that. Not from this witness stand, not from these video cameras. They haven't done that. And again, I submit to you, the simple reason why they haven't done that is because he's listening to the Cowboy game, he's distracted. Shots go off, he bends down. He never looks toward the door. Shots go off, he bends down. That's reasonable, ladies and gentlemen. He looks back. That's what happened. He jumps in. He drives off. Your son says, they're shooting. Go, go, go. They're shooting. Guess what? You get off the brake and you go. What happened? What happened, Mio? What happened? What happened? Just go home. Just go home. I tell you, just go home. That's reasonable. He's 14. He's just done a horrific shooting. He heard the shots. He didn't see the shots. He didn't see the offense. That's reasonable. He gets home. He goes straight to his room. Never sees him with the gun. Let him calm down. Let him calm down because I don't want to get the mom upset. That's reasonable. That's what happened. Is that the smartest thing? No. Of course not. But that's what happened. That's what happened. Ladies and gentlemen, I ask you to find Richard Acosta not guilty as a under the law parties. Not because, that's what I want or because that's what his family believes, but because they simply have not proven this case beyond a reasonable doubt. And the reason they haven't proven it beyond a reasonable doubt is because it happened exactly the way Richard Acosta told you. And no evidence has been presented to you that, in my opinion, or that I believe, proves otherwise, other than their speculation. All this, every time they said pointing and all that, he never said that. He told you where he thought those boys were. They're in the game room. That's where he saw them going when they walked by him. She's going to tell you, no, they can clearly see in there. Can they? Could they? That's not what he said. That's not where his attention was. So they haven't proven that he knew that the boys were in that portion of the store at any time other than when he initially saw them in there. And then he saw him go, thank you, he saw him going to the smoke shop. Ladies and gentlemen, find him not guilty. They haven't proven this case beyond reasonable doubt. Find him not guilty because he is not guilty.
Thank you, Mr. Harris.
Thank you, Your Honor.
Ms. Farley, you have 24 minutes left.
May it please the court. Defense counsel told you that this is a tragedy. This is no tragedy. This is inexcusable. This is unforgivable. And it's indefensible. I want to bring your attention back to Ivan Iola, Rafael Garcia, Xavier Gonzalez, and the families that have been sitting here all week. There's power in the oath that you took. That oath to a true verdict render according to the law and the evidence. These families have put their trust in the criminal justice system. They've put their trust in the oath that you took. And they've put your trust that you will look at that evidence, you will apply it to the law, and you will a true verdict render. There's an old principle of law that says anybody charged with a crime is entitled to a defense. In this case, he's had his defense. Mr. Harris, a zealous advocate, one of the best in Dallas County. But that same principle of law that says anybody charged with a crime is entitled to a defense, that does not mean that every crime is defendable. I will submit to you that the last 45 minutes was the defense wanting you to look at all of the evidence in a vacuum.
totality of the circumstances. It's reasonable deductions from the evidence. And that's what we're gonna ask you to do. Look at it all together. You are the judges of the credibility of the witnesses and the evidence in this case. You get to judge that defendant's credibility. I will submit to you that the only person who is leading a double life is this defendant. That person who took that stand yesterday and tried to present himself to you as a caring, loving, protecting family man. And I will submit to you that everything that came out of his mouth was a ridiculous explanation and an outright lie. In order for you to find him not guilty, ladies and gentlemen, you are going to have to believe everything he said about what you saw. That's what a not guilty will require. You all saw how he was on that stand. Isn't it convenient? Isn't it convenient that the only times where there was not a direct view into the cab of that truck, that his attention was diverted with something? By the pumps, while Abel is preparing for an execution. His attention's diverted because cops might get called out because he hit Armando's truck. Isn't it convenient? And then again, his attention is diverted when they're sitting outside the front doors by the Cowboy gang, as his son is shirtless with a mask, a hat, and you saw the gun. What hand do you think he had to open that door with? So where was the gun? They want you to believe that it was in his shorts pocket? Come on. That's not reasonable. You judge his credibility. What he said, his explanations were ridiculous. They were pure nonsense. They were not reasonable. His attention is diverted, so he doesn't know his son has a gun. And then again, his attention is diverted because he hears gunshots and he ducks. And you never see the truck move. You never see that brake light. I mean, if he's ducking, if he is making a quick motion and movement, wouldn't you have seen that truck move? What he told you was not reasonable. It was ridiculous. The truck. The evidence corroborates the fact that that truck got washed that night at 8:30. Think about it. The cell phone data puts him in the location of 2 car washes. But it's not just a power wash, and we all know that because you saw the mark on the side of the truck. That had to take some doing to get that scuff out of that paint job. He wants you to believe that his son, his chronic runaway son, is gone. This is his mind frame, remember? This is what he wants you to believe. He and his son were at a place that had just been shot up. And I'm going to go ahead and make sure that scuff mark is off of my truck that has been there for almost a month. Sometime between 7:40 at night and 6:18 in the morning. 7:40 at night and 6:18 is evidence. That is corroborating evidence from what y'all saw in that video. What he told you was unreasonable. It was ridiculous, and it was nonsense. Getting rid of the black mark on the truck is an action after the fact that you can take into consideration. Walking into the Garland Detention Center. You saw the video, the body cam video, when he was in that lobby speaking to those officers. I want you to think about his demeanor. What was his demeanor like? And remember, he wants you to believe his mind frame. My 14-year-old son is missing again. I was just at a place where the store was shot up. Don't know anything about it. It's looking pretty cool, calm, and collected, don't you think? Does that make sense? Does that seem reasonable? This is evidence, ladies and gentlemen. It's evidence. It's evidence of his guilt. And think about the time of day that was. It was at 5:30 on December 27th when he walks into that detention center. What had he been up to? The cell phone evidence that you have in front of you has his device, his wife's device, and his son Instagram is pinging all the same location in Fort Worth, the Rocco Apartments, where his aunt lives. That's evidence. And then you have this conversation with somebody he claims he doesn't know. You have a new phone being purchased. That box we saw, that's evidence, and being activated at 4 p.m. You have his device in Lake Ray Hubbard while he's in the detention center. They had gotten rid of the gun, they had gotten rid of the phone, and able to safe. That's what you saw in that lobby. I told you in the beginning, all you need to convict in this case is that surveillance video. The actions speak louder than words. That was my opening statement to you on Monday. And there's a reason why I played that video for 20 minutes in silence. Y'all don't need me to tell you what you see in that video. You saw it, we saw it, we know he's guilty, and he's guilty of capital murder. Because that's what his actions show you. The 42 seconds after he makes his purchase and is back in the truck, I will submit to you, after looking at everything, the totality of the circumstances, a reasonable deduction from the evidence, is that's when the plan was hatched. And they were not in a good position to make a good, quick getaway. They were not in a position for able to be able to sneak up on them, were they? Not in that position. Because remember, while he was inside making the purchase, Abel's checking out, oh, I know who's inside. Let me see if that's their truck. Window down, looking in the side rear mirror. A reasonable deduction from the evidence that you saw, the totality of the circumstances, the actions after, tells you they went over to that other truck by the pumps for a reason. They knew Ivan and Raphael had gotten out of the truck. A reasonable deduction of the evidence tells you they're waiting for Ivan and Raphael to come out. It just took too long. A reasonable deduction from the evidence, with everything that you know now, as they slow rolled, casing the store to see the location of those boys, and stopping, you know what is going on. Abel has no shirt on. He has a mask. He has a hat. And he has that gun. A gun that is almost as long as his little torso. This was not concealed. It's not reasonable. It's ridiculous. It is nonsense to say that he did not know that there was a gun. It's offensive. And just as Raphael turns his back from the door, he exits the truck. Do you think Abel did that on his own? A reasonable deduction from the evidence tells you he had help. He was aided. He knew when it was time to go and sneak up and open that door. Foot on the brake. This defendant knew when to take off. There was no go, 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 they're shooting. His story doesn't make sense. His story wasn't reasonable. So how do you know? How do you know that when you return a verdict of guilty for capital murder, that you are doing the just and the right thing? How do you know? Now we look at his actions after the truck. You all saw what that truck looked like when it was being processed. This is a scuff mark from an accident that happened almost a month prior, that had been removed between the hours of 7:40 p.m. and 6:18 a.m. That is evidence. You have the movement to Fort Worth. Her phone, his phone, Abel's Instagram account pinging at the same place in Fort Worth at about 12:30 a.m. That is evidence. This is how you know that what you saw in that video is exactly what he's charged with. The Garland Police Department, they got it right. They had two suspects. They had the shooter and they had that shooter's driver. They worked diligently to identify them. One apprehended, one not. The investigation's not over. It will continue. And then the next day, now we act normal. Now it's time to act normal. Buy a new phone. Why do you think they bought a new phone? He wasn't even a suspect yet. He wasn't even a suspect yet. Why did they need a new phone? She hadn't been pulled over yet. They hadn't seized her phone yet. Why did they buy a new phone? Activated at 4 p.m. And where's his phone? On Lake Ray Hubbard. That is evidence, ladies and gentlemen, that corroborates, that tells you that what you saw in that video is exactly what you think you saw in that video. What you know you saw in that video. It is inexcusable. It is unforgivable. It is indefensible. This grown man took his 14-year-old son, and when the plan was hatched, he encouraged, he directed, he aided in the execution of those 3 boys, by the way, who had no chance. They never saw it coming. You saw Ivan and Raphael and Xavier all duck when those gunshots came out, when their backs were to the door. You saw Ivan and Raphael try to run for their lives, only to then drown in their own blood. And then you saw Xavier, who tried to protect himself with that stupid little chair. He had no chance. And this man gets his son out of there, gets rid of the gun, gets rid of the phone, and makes sure Abel is safe. We have proven this case to you beyond a reasonable doubt. But for Richard Acosta Jr. encouraging, directing, aiding, attempting to aid his son in the execution of those boys, we wouldn't be here. Find him guilty of capital murder.
Thank you, Ms. Fargo. Ladies and gentlemen of the jury, now it's your time to deliberate. I know Ms. Clifford and Ms. Rutherford, do you all have anything back in the jury room? You do, okay. So when you go back there, I'm gonna ask that you get your items and come back out here and I'll explain what happens next with you. So the rest of you are gonna start your deliberations, and I have a few ground rules to give you. One is that all 12 of you must be present while deliberations are taking place. If someone needs a smoke break or a bathroom break, you need to cease deliberations until all 12 of you are present. I saw a few of you taking notes throughout this process. I need you to leave those notes right there on that little bench on your way out the door. We'll keep those for you. If you'd like to have them back after things are over, that's perfectly fine. You can take them with you then. I just can't have you back there in the jury room with them. If there is a dispute about the evidence or you want to have some testimony read back to you, I know that I said I have a rough draft to read over as this is going. It's just that, a very rough draft. And so if you are in dispute about the evidence, you have to phrase the question in a very specific way. And I want to give you guidance on that, because if you don't phrase the question properly, you'll get a note back from me that says you have all the law and the evidence. Keep deliberating. So if you're in dispute, you need to say, we, the jury, are in dispute about this particular issue from this particular witness. And then we can search through the pages and pages of transcript to find that issue. And again, it will take us time because we have to listen to audio, fill in the blanks, and make it something that you all can read. So make sure you understand that. I just wanted to lay that out there for you. Have I gone over everything, Sasha? Been a minute. All right. With that being said, I do wish you the best of luck in reaching a unanimous verdict. We will be in recess until we have your verdict. When lunch happens at the 12 noon hour, the court is going to break, and so I would suggest you all take a lunch break at that time as well. You are free to deliberate over the lunch hour if you wish to, as long as all 12 of you are present, okay? Good luck in finding your verdict. All right, my jury. There's the